Good morning, everyone, and welcome to Company Service Providers Workshop. It's good to see a good number of attendees in today's session. It has been 6 months since the new legislation introducing CSP regime was enacted on 12th of April 2021. And it has been 3 months since the regime came into effect on 12th of July 2021. We thought it would be a good time to hold this workshop. Since the effective date, we have licensed 35 ADGM-based company service providers. We have more in the pipeline, and that includes conversion of the existing ADGM firms and the new applicants. Further, since the effective date, we have also granted exemption to appoint CSP for several SPVs which qualify for exemption. In today's workshop, we will revisit the CSP roles and responsibilities. We will remind you on how to gain access to online registry solution portal. We'll remind you of the process of appointment and cessation of CSPs and whose responsibilities it is to notify registrar. We'll talk about exempt SPVs appointing company service providers. And we would like to talk in great details about the SPV and foundation license renewal process and recap on CSP appointment transition period. We'll talk about the SPV business plan form and the use of the correct form, and we'll complete with SPV applications and common issues that we observed. Please post your questions during the presentation in the comments box. We will have questions and answer session. At the end, we'll combine your questions and we will try to cover them all. On that note, I'm going to pass to my colleague, Colin.
Thank you, Natella, and good morning, everybody. Any person that conducts the activity of providing company services with respect to an ADGM entity is required to be licensed to conduct the activity of company service provider. Providing company services is defined in the Commercial Licensing Regulations Controlled Activities Rules 2021 and includes any one or more of the 5 services shown, including acting as an incorporation agent in connection with the incorporation or registration of an ADM body corporate, providing company services to any body corporate incorporated or registered in ADGM, acting as a registered office provider, providing directors, secretaries, councillors, registered agent or other officers, and providing nominee shareholders or of companies in relation to any body corporate in ADGM. It is important to note that the general prohibition contained in the Commercial Licensing Regulations 2015 on carrying on an activity whilst unlicensed, and that any person who is found to have contravened the general prohibition commits a contravention and is liable to a fine not exceeding $20,000 US. Next slide. Under the CSP framework, a company conducting a business activity of being a special purpose company or vehicle must at all times have a company service provider, also known as a non-exempt SPV. A CSP who consents to be appointed by a non-exempt SPV has a number of obligations. They include they're required to maintain records of the SPV, for example, registers of members and directors. The CSP must act as a registered office provider to the SPV. The CSP is authorized to represent the SPV in its dealings with the registrar, and that CSP shall give all notices filings to the registrar that the non-exempt SPV is required to under the company's regulations 2020, the Commercial Licensing Regulations 2015, and the Beneficial Ownership and Control Regulations 2018. Please note, the registration authority will only deal with the validly appointed CSP in this case. It will not deal with the SPV or any other person. Any person claiming to act for the non-exempt CSP other than the validly appointed CSP may be viewed by the registration authority as acting in breach of the general prohibition. Furthermore, the validly appointed CSP may be failing to comply with its obligations under the law. Next slide. The obligations similarly apply to those CSPs who are appointed by non-exempt foundations. Only the CSP validly appointed by the non-exempt foundation are authorized to represent the foundation in its dealings with the registrar and give the relevant notices and filings. Again, the registration authority will only deal with the appointed CSP. Next slide, please. CSPs are reminded that they must ensure that they comply with the specific conditions of license on an ongoing basis. These include conditions on fitness and propriety, having adequate policies, procedures, and controls in place, maintaining appropriate professional indemnity insurance, and maintaining adequate financial and system resources. As a DNFBP, a CSP is also required to comply with AML rules and maintain effective AML policies, procedures, and systems and controls to prevent opportunities for money laundering. Next slide, please. The Registration Authority's Monitoring and Enforcement Division is tasked with supervising ADGM licensed persons for ongoing compliance, including compliance with its conditions of license. Pursuant to a delegation from the FSRA, the Registration Authority also supervises DNFBPs for compliance with AML rules. The Monitoring and Enforcement Division conducts planned on-site assessments of ADGM licensees, including CSPs and DNFBPs. If selected, you will be notified of the assessment in advance. The assessment will involve a review of documentation and a meeting with the MLRO and senior management. Similarly, an ADGM company, SPV, or foundation may be selected for assessment. If you are an appointed CSP of the entity, you are authorized to represent that entity during the assessment. CSPs were appointed by non-exempt SPVs and foundations under the CSP framework must request to be given authority to the ADGM online registry system, also known as ORS. Please note that the Registration Authority will only permit new ORS access requests sent from the appointed CSP of a non-exempt SPV or foundation. Note, do not share authorized ORS login details with any unauthorized party. Remember, only the appointed CSP is authorized to represent the non-exempt SPV or foundation and give all notices and filings. Finally, a CSP can view and check who has access to the entity by clicking on the Maintain Authority button at the top of the registered entity details. So you can go in there and check and delete or amend as required. Next. A non-exempt SPV or foundation must, within 14 days of a person becoming or ceasing to be a CSP of the SPV or foundation, give notice to the registrar of the change. Failure to comply is a contravention and you'll be liable to a fine of $300. Further, the CSP must provide its written consent to be appointed. CSP appointment and cessation forms are available on the dedicated ADGM micropage, and you select Operating in ADGM. You email these forms to the email address monitoring@adgm.com. Next slide. Please note, it's important that non-exempt SPVs that fail to appoint a CSP commit a contravention of the company's regulations and is liable to a fine not exceeding $25,000. Furthermore, the non-exempt SPV may be subject to the registrar's new striking off powers as contained in the company's regulations. Similarly, non-exempt foundations that fail to appoint a CSP also will commit a contravention of the company's regulations and also liable to a fine not exceeding $25,000.
So it is not unusual for an exempt SPV or foundation to engage ADGM licensed CSP. That is fine, that's not against the rules. But should you select that option, then exempt SPV or foundation is still subject to the duty to notify the registrar of such appointment, which is specified in Section 296C of the Companies Regulations and Section 18.7 and 8 of the Foundation Regulations. So once you select the CSP, the notification requirement is applicable to you. You still have to notify registrar within 14 days. The CSP still needs to sign a consent form, and the CSP appointment form should be emailed to monitoring@adgm.com. And failure to provide that notification makes you liable to a fine. Next. Now let's talk about the license renewal process in great details. Now, application for license renewal is quite a lengthy form. This form requires that you confirm every field that's listed in your records, which are kept with the registrar, are still valid and still correct. So it's good to prepare for license renewal in advance. The online registry solution will send you automatic compliance reminders quite early on. It starts probably 3 months before the license renewal. And the system keeps sending you reminders first a month later, then 2 weeks later, and 2 weeks later again. And as the renewal date approaches closer, the language of reminders gets stronger. So you have plenty of time to prepare for application for license renewal. Now, if it is a non-exempt SPV or foundation, you have to appoint the CSP prior to your renewal date. So at the time of license renewal, you also lodge the notification of appointment of CSP. Now, steps to complete the license renewal: access your dashboard, review and complete the form. Make sure that all the information that is in the form is correct, because if any of the information is outdated, you have to file a notification of changes. So get ready, get prepared. Notification of changes may take time. If everything is in order, you confirm every page, you tick box the declaration, pay the fee, and lodge the form. Now, we grant 30 days grace period to renew your commercial license. Please make sure you renew it on time and you don't go beyond 30 days. If you're late to renew your license, you're subject to general prohibition in Section 1 of Commercial Licensing Regulations, which Colin mentioned earlier. Just to remind everyone, you cannot conduct any activities in ADGM without the valid commercial license. If you do so, you're subject to a penalty of $25,000. And next slide, please. Just to recap and remind everyone about the transition periods. All those SPVs that were registered before the new regime came into effect, they must appoint a CSP. If they're non-exempt, they must appoint a CSP at the time of license renewal. So if you're already handling files of non-exempt SPVs, so business goes on as usual. You just have to provide us with notification that you are the appointed CSP. If SPV is non-exempt and it doesn't have CSP appointed, it must appoint the CSP at the time of license renewal. Next slide. Okay. Now let's talk a little bit about the new form of the business plan. We have noticed it in many occasions that the outdated form of the business plan has been used simply because you saved it earlier and you keep it in your files and you haven't uploaded the new one. Please visit the CSP micro page on our website. Download the latest form of the business plan for non-exempt or exempt SPVs, whichever your client qualifies for. Download the latest form and please use that form. Please don't use the saved versions. They may not be the most updated versions. They may have changed. Next slide. The new form of the business plan contains many new sections and, very importantly, declarations. So it's very important that you use the updated form of the business plan. Please do not use the old forms of the business plan. Both forms of the business plan has changed, and we would really appreciate if you use the current version of the business plan. Now let's talk about the application for incorporation of SPVs and foundations and the common issues that we have observed. Very often, the supporting documents that are lodged as evidence of certain facts stated in the application form are either outdated or they're expired. So it's very important that if you upload a passport copy or a commercial license as a supporting document, please make sure that this document is valid, that it's not expired document. Very often we encounter errors in the details stated in the fields of the application form. For example, the name of the person is not spelled as per passport, or the name of the body corporate that holds the role is not spelled as per the company certificate of incorporation or registration. Very often we see that the country of residence is stated as United Arab Emirates because that's a default option. So because it's a default option, it's already filled in, and applicants very often don't pay attention to it. So please pay attention to the country of residence of the role holder. Sometime we notice that the business plan does not contain the signature of the company service provider or the shareholders. Please make sure every part of the business plan is completed. Very often we see supported documents uploaded in the wrong part of the application form. For example, a certificate of incorporation of the shareholder is uploaded in general details instead of in the shareholder tab. So make sure it's uploaded in the right place. It's easier for us to review it that way, and we don't have to return the application just to ask you to upload the supporting documents in the correct parts of the application form. Please pay attention to the data protection section of the application form. Very often the answers contain irrelevant entries or not relevant answers. The expiry date of the documents most often applicable to passport copies, visa copies, or the supporting documents of the body corporate that holds the role. For example, we accept most recent and relevant documents, and we request that these documents are issued not earlier than 3 months before you lodge the application. So please make sure that the supporting documents for the body corporate are issued in the past 3 months, not earlier than 3 months. Then we consider them no longer recent and relevant, and therefore outdated. So these are just some examples of the most often occurring issues with the application forms. Just pay attention to those details, make sure that information is valid, correct, most recent, most relevant, and filed in the right places of the application form. On that note, I'm gonna move on to the next section of our workshop, which is questions and answers.
Good afternoon, everyone. Please send your questions in the chat, and we'll do our very best to answer each and every one of them. While we wait, certainly I'd just like to perhaps reiterate the responsibilities of being appointed as a CSP. This can be found in section 296B of the company's regulations. In particular, you'll need to go to the Companies Regulations Amendment Act number 1 of 2021. As I mentioned before, a CSP of a non-exempt company must maintain records that the non-exempt company is required to keep. So these includes things like register of members, register of directors, register of secretaries, records of resolutions, contracts relating to purchase of shares, register of debenture holders, and there's a few others. And in addition, a CSP is also responsible for submitting filings that are required under other regulations, including the Beneficial Ownership and Control Regulations 2018. So if there's been a change in the beneficial owner, there'll be a requirement to file a notification to the registrar notifying of that change. Finally, the other obligation, as I mentioned in the presentation before, is that if you are appointed as a CSP, you must act as that registered office provider to that company. Secondly, you as a CSP are authorized to represent the non-exempt company in its dealings with the registrar. So we will not deal with any other CSP, only the validly appointed CSP. And yes, they're probably the main obligations.
So we have our first question posted in the comments. The question is as follows. I'm the appointed CSP for non-exempt SPV. CSP wishes to resign. Can CSP resign, and what are the steps to be taken? Good question. Now, CSP may resign. It's your right. And of course, make sure that you check the contract that you have with your client. But Section 296C of the company's regulations state that the notification is required. And there's more details about the resignation of CSP in the commercial licensing regulations controlled conditions of license rule, Section 12.6 to be precise. It says that the company service provider may resign by giving notice in accordance with the relevant provisions and obligations in their CSP engagement contract. But in the absence of express provisions, the CSP must give notice to a non-exempt SPV 30 days notice. And also, in addition to that, CSP is required to notify the registration authority within 14 days of their resignation. So the answer is yes, you can resign. Make sure you check the provisions of your engagement agreement with your client. Make sure you give them 30 days notice, and make sure that you notify the registration authority within 14 days of your resignation. Now that actually leads me to another part of that procedure where CSP ceases to be an appointed CSP for a non-exempt or exempt SPV, depending on the circumstances. So cessation may take place under different circumstances. Let's say you're removed by the non-exempt SPV. Again, that's prescribed in the Commercial Licensing Regulations Conditions of License Rule, Section 12.7, which provides the details of what are the actions of CSPs and SPV, what are the obligations of each party towards the registration authority. So if you resigned or been replaced at the CSP, there are certain obligations that you have because you're licensed CSP. It is your obligation to make sure that you hand over all the records and all the documents that you hold for that SPV to the next CSP appointed. You have to facilitate the smooth transition from current CSP appointed to the next one. So it is definitely your obligation to do so. You cannot just go ahead and say, I resign and that's it. You have to hand over all the records, all the history of this SPV with registration authority, all this previous statutory filing, supporting documents, and you have to facilitate the transition. So I hope that answers the question. Let's check the next one.
I'm sorry, I was on mute. So the question was, upon approval of the new CSP license, will the commercial license date of the CSP be amended to this date? Existing licensee who's applied for the new CSP activity, company service provider, as soon as it's approved, it will be effective that date. But as I understand the system, that date will not actually be reflected. So basically, the actual your commercial license renewal date will not be affected.
I can just add to this. So the commercial licensing date does not change. The first issue of commercial license remains as is, and commercial license is renewed every year. Addition of new CSP activity does not trigger a new date for commercial license. We have another question. The question is, CSP is required to maintain the documents of the SPV. Is there any specific guidelines on the location of the server where these details to be maintained? I believe this question is much broader than CSP regime. This question relates to where can you keep the data and on what server you can keep the data, and that I'm not an expert in digital data and where it can be saved or stored. I think you have to look at broader legislation and probably federal legislation in UAE.
Just following on that, I confirm there's no specific guidelines in terms of location or server, but we definitely do obviously have record keeping requirements, and the fact that those records should be available for inspection at short notice.
We have next question. There are certain additional forms which are requested only after the first submission of the application, like name declaration. Should such form be prepared in advance when incorporating other SPVs and lodged in the first application of other SPVs? Okay, I'll take that question. Now, very good question, thank you. I agree that not all the forms are available in the online application, and some of them are requested after you lodge the application for incorporation. That's correct. These forms are requested only if there are questions asked about the proposed name. For example, and you could prevent asking us to submit that form by making sure that you check if the name is available. Look at our name rule and look at the conditions related to proposed name in the company's regulations. The conditions are as follows. The name must be available in ADGM, which means you have to run through the company's search in partnership and foundation search and key in the words that you want to use in the proposed name. Make sure the name does not match or either exactly or in a very similar fashion to already existing registered name, because you should not have a name that is very similar to already registered name. It will cause confusion between your company and the other company. If you're related companies, you have either implied consent from related company or expressed consent. For example, if a parent company has very similar name and parent company passes a resolution to set up a subsidiary, you already have a consent there, so you don't need to provide a consent. So make sure the name is available, make sure the name is acceptable, and it doesn't contain any restricted words or expressions. Those are stated in the name rule. We have the name which sets out what names you cannot use and what names would require specific approval from the registrar, because the registrar is a final authority in deciding whether or not the name can be permitted. Now, there's other forms that we may ask in addition to what you already provide in application for incorporation. The standard forms we do ask are economic substance regulations form. You probably all have that form by now. That is compulsory, so please provide them in advance. The nominee forms for shareholders and role holders. Those are also standard forms we would like to see when you submit your application for incorporation, so you can provide them in advance. We may ask you for source of wealth or source of funds for certain individuals who hold roles within the ADGM entity, but that depends on the risk rating of the application and an individual. So not all of them are required. I hope I covered that question.
We have a question about the CSP appointment form. Will you consider including the consent to provide registered office in the CSP appointment form? The appointment form already has the consent on it, and by consenting to it, you will be basically acknowledging that you'll need to discharge all the obligations as required under the company regulations, which includes being the registered office provider.
Follow-up question to that. So what happens if, so would CSP then be permitted to provide CSP appointment form instead of consent to use registered office address? Perhaps consent to use registered office address is a very expressed consent. So we would still ask for that document to be uploaded in the address section. We have a next question about the resignation of CSP or cessation of CSP. Once we exited from the CSP role and hand over the documents, are we still required to keep the documents of the statutory time for the statutory time limit for retention of documents for the period we served as CSP?
I think that's a good question. I think the key touch point is the fact that there's an obligation for the existing CSP to hand it over to the new CSP, at which point I would have thought from a practical point, then any requirement to retain it ceases because you are no longer the appointed CSP. So to order allow for a smooth transition from one CSP to another, you will need to abide by the rules to cooperate and provide those documents. And as I said before, I would say that once you have then ceased being a CSP and the new CSP has all the relevant documents, and then those obligations would not apply.
So the next question is a follow-up question on previous discussion. Yes, we do insist on the separate consent letter because that is an expressed consent to use the registered office address for the period of the license duration. So yes, we would like to see that uploaded in the address section. There's one more question. Does the CSP need to act as a formation agent? Now, yes, you do, and that is prescribed in the Commercial Licensing Regulations Controlled Activity Rule, Section 7.2. So it goes with the scope of your license as a company service provider, and what does it mean to provide company services? So one of those meanings is listed in that section is acting as the incorporation agent. So the appointed CSP acts as an incorporation agent and then continues to act as the CSP throughout the life cycle of the legal entity until you cease to be the appointed CSP, either by way of resignation or removal. All right. Looks like we had
one more question.
Yep.
The question here is about supervision. Can you tell us a little bit more about supervision, what the monitoring team will be looking out for, and what should CSPs do and not do? So further to the earlier part of the presentation, it's important to note that only the appointed CSP, the validly appointed CSP, is able basically to discharge all requirements under the company's regs. That is, all the filings and other requirements that the SPV is required to comply with.
Recording in progress.
It's important to note that anyone other than the appointed CSP who is viewed as performing CSP activities and are not licensed and are not appointed could be in contravention of the law. So certainly we'll be looking at those perimeter issues. Similarly, also with the use of ORS, the online registry system, do not allow any unauthorized third party to use it. Only the appointed CSP and their employees should have access to ORS. The onus will be on the CSPs now to check that all current access is accordingly given only to those authorized to use it. We don't have view over that, so it's really important that CSPs go through their authorized access and review that accordingly. Thank you.
We have one more question. The purpose of SPV and whether or not it is completed as stated in the proposed business plan within 6 months from the date of incorporation. The question is, in case where the future investments are not yet incorporated in the GCC and they would only be incorporated after the creation of SPV, does the monitoring team allow such purpose of SPV? I think the question is for registration team. So when we receive an application where it says the purpose of SPV is to invest in a legal entity to be incorporated in GCC, we would accept that application provided that the nexus to UE or GCC is met. So you have to meet you're all familiar with the policy which is called nexus to UE and GCC. We rely on that policy very heavily when we review the applications for SPVs, in particular when we review the business plan and the purpose of SPV. So please make sure that at least one limb of that nexus policy is met. There are 3 limbs to it. One is controlling shareholder is UE or GCC national or UE or GCC resident. The target asset is located in UAE or GCC. The transaction that this SPV facilitates is located in UAE or GCC. So when you submit the application where the target asset is not in UAE or GCC, it does not exist yet. You have to make sure that you meet to either of the remaining 3 limbs of the nexus policy. Otherwise, there will be questions asked such as, how do you meet the nexus policy, which is in place and is currently being implemented? Well, we had a very good number of questions here. I think we covered them all. I don't see any more questions coming in. We can wrap up the session now. The webinar recording will be available for you to revisit again. So we won't be circulating the slides. Slides are on the webinar recording. You can revisit again. You can look at the slides again. I think we had a very good session and interesting questions. If you have more questions after the webinar, please send them to us to our usual email addresses, either monitoring@adgm.com or registration@adgm.com. Thank you very much for attending this session and have a good day.